Welcome. Good evening, everyone. Great to see friendly, tired but determined faces around the circle tonight. Welcome, everyone, to tonight's Discipline Matrix and Ad Hoc Committee, October 1st, starting a couple of minutes late at 6:08, but I'm glad to have everyone with us. Let me check to see if we have any participants in attendance. No, we don't. We're joined tonight by Deacon Lyles, Commissioner Riles, Commissioner Jackson Castaigne, and the star of our traveling band here, DC Hubbard. Great to have you here, sir. We've had some fruitful discussions, and we're going and trying to wordsmith a few things last week. So I can imagine we're going to go back and review some of those edits, and then pick up on the next parts of the discipline matrix of where we left off. But I do apologize. I don't have my notes in front of me, so I don't know exactly where that at. So I'm going to lean on you, sir, if you could kick us off,
Sure thing.
please.
Can you see my screen?
Yes.
Yes.
Yep.
Okay, great. So I want to go over subversive organization. I was tasked with coming up with a new definition that uh, addressed unauthorized subgroups within the department. So I certainly went down a rabbit hole. I'll show you some of the reading that I've been doing also, and I'll send this later to you via email. But for subversive organization, this is our previous definition. Remove knowingly and added associate with, and then also there was uh, talk about how organization and group can be somewhat interchangeable throughout this definition. So I removed group and just kept it as any organization or gang. Uh, let's see, I should have. So I think we're good with this. I think we want to spend a lot of our time talking about this new definition that I have here regarding unauthorized subgroups within the department. Uh, I I refrain from calling it subversive just because that really limits us on based on the definition of a subversive organization. I'll come back to that, but I put a lot. Excuse me if I skipped this. There's a lot of articles that I read just with gang activity, if you will, within organizations, and I'll send you these links if you're interested in some weekend reading, but it's very interesting. Just and so I kind of gleaned this definition from what I read within these articles. There's a lot,
Wow.
and I actually forgot about this, but Assembly Bill 958 from 2122. It requires all California law enforcement agencies to maintain policy prohibiting participation in law enforcement gangs, and then participation must be grounds for termination. It reminded me, Chair Emeritus Regina Jackson, she was on vacation and she texted me, and this is probably a few months ago, asking me if we ever published a policy regarding this, and it was specific to white supremacists, like the theme behind that. And I remember her asking this a couple years ago at a commission meeting, and I don't think there was any follow-up. So one task that I'm probably going to pass off to our policy and publications team is to make sure that the assembly bill is actually it actually comports with law, number one, but also kind of going back and make sure that we didn't miss the task of creating a policy that talks about what I'm going to talk about here tonight. I don't know if that rings a bell for the other commissioners on this call now, but yeah, I got that text and I remember that a few years ago.
So, one, sir, impressive, and thank you for all the work put into this. Definitely look forward to reading some of these articles. And so to be clear, so the question is, this part of the policy that you're adding right now that you're going to share right now, it's embedded in another MOR. You're saying it might need its own standalone policy.
Policy, yeah. So this would be
Okay.
the MOR. If you do violate it, these are the consequences. But yeah, it definitely warrants, I think, a standalone policy. Yeah.
Okay. Got it.
Okay. I'll come back up here. So this is what I came up with, and please provide any input. No member or employee shall form, join, participate in, or support any unauthorized sub-organization within the Oakland Police Department that operates outside the established chain of command or official departmental structure, engages in activities that undermine departmental policy, leadership, or legitimate operational directives, promotes loyalty to a subgroup over loyalty to the department and its mission, engages in or facilitates conduct prohibited by law, departmental policy, or professional standards, uses symbols, communications, or services that create a separate identity or allegiance apart from official departmental affiliation, or intimidates, retaliates against, or excludes members based on their refusal to participate in such subgroups. This prohibition applies to any informal association that functions similarly to a gang, clique, or secret society within the department, regardless of how it is characterized by its members. The designation of an unauthorized subgroup will be based on a preponderance of evidence demonstrating that the group operates contrary to departmental values, chain of command, or professional standards. Participation in officially recognized employee organizations, labor unions, professional associations, or departmental committees or task forces authorized by the chief of police is not prohibited.
And this is law now. This is California law.
Well, this is not from, I mean, I kind of created this from that, yes, but this is not how it's read in the legislation.
I think
Okay.
it's really comprehensive.
Yeah, but we got to give our officers a chance here.
Yeah.
If this is California law, and that's my assumption that the Assembly bill was passed and it became California law. So if it's sitting law, then we should cite it in the document in our policy. And so this is not just some liberals not understanding police culture. This is California law.
Sure.
And so we gotta. I'm curious as to what is the penal code section for this.
Let me see here. See if I can.
And so we should have cited the penal code and not the Assembly bill, because that leaves it up to be like maybe this is not settled law, but it is settled.
It is, yes.
Yeah, that's a great suggestion. I like the idea of just giving it even more teeth, that it's beyond this.
I think I found
this
it.
document. Yeah,
I think I found it. I think it's California Penal Code 13670. I guess that's the government code. No, it says penal code here. Section 13670.
Great. Let me see if I can. Yeah. Yeah, you're right. It might define, I mean, it goes into the definition of gang, and it talks about how they identify themselves, symbol matching tattoos, etc., and then prohibited behavior. But yeah, I agree with you. So I can update this to reflect the law.
Yeah, subsection 1. Law enforcement agency means any department or agency of the state or any local government, special district, or political subdivision thereof that employs any peace officer as described in 830 PC. So yeah, this is the one we want to cite.
Got it. Yeah, will do. Is there anything in this definition that stands out or is concerning? I was just thinking of, like, like we all get together and we have a softball team. I don't want that to be considered a subgroup that works against the.
Well, there's some bullet points here that would make the distinction between a softball group or a singing group or a band,
Yeah.
of officers or something. But some bullet points here: excluding, harassing, discriminating against any individuals, engaging in promoting conduct that violates the rights of other employees or members of the public, practicing unlawful detention, use of excessive force, falsifying police reports, targeting. These are the elements that make these folks part of this group, part of a subversive group if they're doing these actions. So somehow we ought to be able to direct our officers to that, and so they can read it for themselves. If you retaliate against an officer, if you're part of a group that retaliate against an officer, or if you lie to protect somebody from a disciplinary action, I knew nothing of this law.
Yeah.
I'm a bit ashamed here. This is exactly what's needed, and that speaks to that speaks to the problem we're dealing with. How can this become law in 2021 and we not know about it?
Right. That is concerning. Okay, being that there needs to be a standalone policy on this, I may shorten this just because this is not supposed to read as a policy. It's supposed to be it's supposed to read as, did you violate this policy?
Right.
So I'll reference it, and I think I'll take a shot at I'm not very good at delegating, so I might just take a shot at actually writing the policy myself and see where that gets us.
Commissioner Jackson Castaigne, I see you have your hands up.
Thank you. Do we need to have something that also references individuals that know about these organizations and don't report them?
Whoa. I would agree with that. That could be included in the policy, where you said,
Yeah, like there's got to be some sort of punishment for them too.
No member shall form, join, participate, know about it, and keep secret an organization without. It should be all up in that the first paragraph.
Got it. Okay, I'll add that. Okay. All right, anything else that I should consider as I work through this?
In the policy 13670, look at subsection B as in boy. I'll just leave it there and let you look at it. I won't go into the explanation.
I might call it what it actually is, which is gangs instead of subgroups. Also,
You reference gangs in there though, right?
I do.
Because I feel like subgroups is more broad and definitely encompasses gangs. Do we think that gangs would be too narrow of a definition? But some groups don't necessarily consider themselves gangs,
Right,
even if they behave like one.
right. And I don't know if, so they call it law enforcement gang in the legislation.
Oh, they do.
They
That's right.
do, but then it's almost like regardless if you use the word gang, your behavior is what dictates you violating the law. So I think that's really more important than it's like, well, just because you say it's not a gang doesn't mean that you can get away with it. Yeah. I mean, they use matching tattoos, pattern of on-duty behavior that intentionally violates the law. Yeah. Okay. Well, I'm glad I went down that rabbit hole because I should have known that this became a and I didn't. So I will get on it. I was also, if we moving on to the next one here, I was also tasked with looking at other departmental manual of rules, and I found the following: NYPD, Chicago, Seattle. They have like three different ones. Maryland statewide, Oregon, a branch of Oregon, and then South Bend. I'll also send this to all of you. They're in the form of a PDF. I guess I would say Seattle was pretty good, but for the rest of them, I'm pleasantly impressed on what we have come up with thus far because I think we far surpassed what they have to offer. But I definitely I haven't read through all of them yet, but reading through them kind of gave me some ideas on what we can do to make ours better. So I will send that out also to you all. They're all in PDFs if you click on the link. Any questions on that? Okay. For endorsements and referrals, we talked briefly about this last week. I just added misuse one's position or resources to suggest. So members and employees shall not misuse one's position or resources to suggest, recommend, advise, or otherwise offer counsel concerning the procurement of a particular product or professional service, whether or not a fee is exchanged. So that was suggested 2 weeks ago. And there's no questions on that. We also talked about retaliation. We agreed on this definition, which is not too much different than what we talked about before. But one question was asked is how do we keep people accountable for retaliation? And we, as a committee, a few months ago came up with our own definition, a new section, which is 398.74. And I'll go ahead and read it for those who are not familiar. Supervisors, commanders, and managers shall be held accountable for failing to report retaliatory behavior among their subordinates if it is deemed that the supervisor, commander, or manager knew or should reasonably have known the retaliatory behavior was occurring, with reports made in accordance to DGO M3, and that's our complaint taking policy. These leadership personnel are responsible for providing an atmosphere in the workplace in which department personnel are free from retaliation and must ensure that employment actions are appropriate and not motivated by or in response to a member employee engaging in a protected activity. Retaliatory actions that are prohibited include, but are not limited to, unfavorable changes in work assignments or schedules, unwarranted disciplinary actions or performance evaluations, exclusion from training or professional development opportunities, hostile work environment or intimidation tactics, and interference with promotion or advancement opportunities. Additionally, supervisors, commanders, and managers shall document all complaints of retaliation reported to them, maintain records of actions taken to address retaliation concerns, and follow up with affected personnel to ensure retaliatory actions have ceased. So that is a new section. Any questions on that?
Can you just leave the screen up for a second? Well, keep reading through it one more time. Hi, Chair Meredith Peterson. Good evening. I see your hand is up. Hey, hey. You're still on mute.
Good evening. I cannot get to you guys until around this time because I don't finish my playground assignment until about 6:15. But I was listening from that point on, and there was a discussion about a law that we had somewhat summarized, I think it was. Deacon Lyles took us to the actual law, right?
Right.
Right. Okay. So I would just caution us in the future that we don't want to try to summarize laws because we may drop a may or a shall, um, and the officer would find him or herself uh, challenging whether uh, they had adequate notice of what they were violating. So it's always a good idea to just cite the actual law or reference the actual law if we're attempting to somehow summarize it to make certain that the officer knows that this is a summary and the full text is wherever it is.
Mhm.
So we should include a disclaimer in there that this is the
Yeah,
summary.
this is a summary. Reference them to the actual
Right,
law
right.
because otherwise you're going to get them saying, "Well, I this is what they told me it was. Now you're saying it's something else." So always make sure it's a CYA that we're just trying to summarize. This is a summary reference to the actual whatever.
Yep, agreed. Yep, thank you for that. Okay, any questions on 398.74? Okay. All right, so last or 2 weeks ago, we finished the list of violations where the first offense is termination. So I thought we would then move now to where the second offense is termination. So for example, we'll take the first one, 314.04-1. And nope, that's not what I want. You'll see here 314, oh, that's one, 314.04-1, conduct towards others, harassment, discrimination. If it was the first offense, the lowest point is actually a 30-day suspension, the highest being termination for the first, but the second one is termination. So if we go to the definition, 314.04, I can we did not change the definition in our work up into this point, but I'll go ahead and read it. Members and employees shall treat all persons with courtesy and respect. The department has a zero tolerance policy for harassment and discrimination against members, employees, and persons on the basis of race, religion, national origin, marital status, age, sex, sexual orientation, ancestry, physical or mental disability, or medical condition. The department prohibits conduct that violates the specified city administrative section instruction, excuse me. Any member employee who harasses or discriminates against another member employee or other any person or engages in any inappropriate workplace conduct that violates city administrative instruction 71 shall be subject to severe disciplinary action, uh, including discharge from the city service. Any member employee who has knowledge that another member employee has engaged in harassment or discrimination or inappropriate conduct that violates the specific city administrative instruction is strictly charged with the responsibility for reporting that conduct in accordance with the provisions of Manual Rule Section 314.48. So again, that is first offense, 30-day suspension to termination, second offense, termination. How do we feel about that?
Why is this considered progressive? Usually progression progression is a first, second, and third. I'm just curious. I don't have a problem. I'm just curious why these were carved out to be second and not termination on the first offense or given more progression.
Um, yeah, I unfortunately don't have the historical context, but I can tell you So this is specific to harassment and discrimination. There is a class 2 section for this, or they call it unprofessional conduct in violation of AI 71. This has been a very confusing section for many of our cases. Uh, because you can see it as, well, your conduct violated AI 71, but it fell short of harassment and discrimination, but it has a very wide range here, counseling and training all the way to a 30-day suspension, which makes it very difficult for anyone to make a equitable decision based on that. The second
Yeah,
one is
yeah.
reprimand, and then, so I'm not
It's-
entirely
it-
sure why this progression is so short.
yeah, it comes to me as gray and providing a lot of gray and leeway
Mhm.
and subjectivity to the deciding official as to whether it rises to a first offense or the other section that you referenced.
Mhm.
So can you give us some examples
Um,
where this hair splitting is clear?
Sure. I'm trying to think of some.
Don't mean to put you on the spot, but it just seemed like a whole new world that's carved out for second offenses rather than just termination.
So the AI 71 prohibits jokes, and let's say that I decide to one day make an unprofessional joke that of a particular race. Is it harassment and discrimination, or is it just unprofessional conduct? And so there needs to be, of course, the burden then is on the subject of that to make that argument, whatever in their interview, but also the investigation to come to a conclusion. But possibly, if let's say it's a one-off, the person comes in and say, "Yeah, I was completely unprofessional. I'm sorry. Just that I'll never do that again, or I haven't done that in the past." Then we would probably consider the class 2 section here. Up here, though, if it's like this ongoing pattern of misconduct, multiple people saying, "Oh, this person makes these jokes all the time based on a race," one can make the argument that it's harassing and discriminatory. So be more severe. So that would be an example of where that jump may happen.
But isn't that already the law that you kind of, I guess you do get one pass at being um, a jerk. Um, and the second time it's serious. Okay.
Yeah.
Why is there so much? So then you open up the whole reprimand, a verbal warning, reprimand, 5 day, 10 days suspension, whatever, in this category of
Right.
offenses.
And so typically what we would do, let's say that they are indeed sustained for the class 2, we would actually start at 15 days because that's in between counseling and training all the way up to suspension 30. And then there would be a mitigating, aggravating argument within that. So if the person apologized and said, "I'll never do that again. It was foolish of me to do," that's a mitigating factor. And aggravating would be, "Yeah, I said it. What's the big deal?" That would be aggravating. But again, it does cause challenges because, that it's pretty broad. That's a very wide range.
Yeah, yeah. I'm struggling with this one.
Yeah.
Someone else can weigh in, but I'm struggling with it.
What's making you unsettled?
Well, I guess it's just that these are second offenses
Mm-hmm.
that might carry the same disrespect, if not uh, discrimination or harassment, as a first offense, but you're saying we're going to open up a whole new playground for you on the second offense, to let you go at it, get another pass, I guess. And I suspect there's no I'm away from this area of the law now, but as I recall, it was kind of a zero tolerance of this behavior, and not okay, now you've done it again, and we're gonna weigh it. Well, all the previous offense would be taken into consideration, right? The fact that you've done it before.
Yes, yes, because one of the elements of harassment is pervasiveness.
Yes.
Pervasiveness, what is the other two? Severity and if you are doing something to a protected class, and something.
Yeah.
So pervasiveness, if this your second shot at doing the same thing that you apologized before, one could argue that's pervasive, and then you get a more severe penalty.
Level of punishment as a second offense.
Yeah.
Okay.
I thought the second offense was termination.
Yeah, for this section, the class one that we're talking about, it is indeed termination.
Yeah.
So it doesn't open up a whole new range of first offense, second offense, third offense.
Not for the class one section. The class two, it does. And we'll get to this a little bit later in our talks, not tonight.
Isn't this what we're talking about right now, the second offense?
No, we are, but this is it right here. It says termination. So
it's still terminate. Oh, second offense is terminate.
Right.
I'm sorry, I misheard you.
That means it's pervasive. So yeah.
Yeah, got it.
Yeah. Class one, second offense, but then there's a class two second offenses are the ones that are a little murkier, sounds like.
Yeah.
Okay, I got it mixed up. Thank you.
Are we okay then with keeping this as termination for the second offense?
Yeah.
Sure.
Okay.
Yep.
Great.
But make sure you flag that when we get to the other thing you were talking about, the other violation.
Yeah, that's only part of the fun. When we get to these other ones that are very wide range, that's where I think it becomes more and more difficult.
Then that's what I was referencing. So
Yeah.
sorry.
Okay, not too far behind is 314.05, and this again, this is conduct towards others, workplace violence. Carries a little bit different weight on the first one. This goes to a 5-day suspension all the way to termination, but the second offense is termination. I'll go ahead and read the section. In order to provide a safe and appropriate work environment, the department has zero tolerance for acts and threats of violence. Employees and members shall report threats or acts of violence or intimidation between members and our employees to their supervisor. Supervisors are responsible for immediately reporting threats or acts of violence and intimidation to the Internal Affairs Division. The following terms are defined as follows: threat, an expression of intention to hurt, punish, intimidate, etc. A threat of violence includes threats against people or property. Violence, intentional physical force used so as to cause injury or mental or emotional harm. Okay, so again, first offense is a 5-day suspension all the way to termination, which is indeed broad. And we can talk about that, but the second offense, termination. So one way to looking at this, and it's a little bit unfair because we are talking about second term, but if we want to spend some time talking about this, especially for those who aren't part of the initial discussion, you want to put yourself in the position of the discipline committee, and here internal affairs or the CPRA comes before you and says, okay, we agree that this is a stain, but we're struggling with the level of discipline. And so you would then ask, okay, well, what's the range? And we give you, well, you have a choice between a 5-day suspension all the way up to termination. And that is a pretty broad jump. So the question tonight is just even ignoring the second offense, which is easy, termination. Do we want to reconsider the first offense to make it a little bit more winnable on the range.
And when you say winnable on the range, what do you mean?
Winnable for all of you, because I think the chair will agree, because I've sat on a few discipline committees with him, and this range is difficult, and it doesn't, we start in the middle point. So from S5 to termination, I would say the middle is about S20, so 20-day suspension, and then you aggravate, mitigate from there. But the broader the gap is, it's, harder to get an agreement between all the parties.
And part of the difficulty is, depending on the circumstance of the nature of the actual violation, starting at that middle at 20 may not be a good way if we're really trying to encourage progressive discipline and learning opportunity. And I mean, I guess, frankly saying, it might be too harsh in some cases, right? And then that's when the disagreement happens, because we're looking at I guess different ways of the actual process. So I guess what I'm struggling with is, the range is the range, and I'm not sure what I think about the range. Like, do we narrow it? Do we start at different starting points, right, within the actual range itself? For me, what I think is more important is the actual process of how you begin to determine that within the range, right? So even the practice of starting in the middle, even though that's been a general practice, we've been in different spaces where that's been contended on, and people have different ways of doing it, right? And so I think that process itself, and how you go through it, and then weigh out the mitigating and aggravating, and where you start, I think that's where we need to, I know there's other discussions with the city attorney, with the chief as well, to try to determine, well, how do we standardize that practice? That way, no matter what commissioner is sitting in that discipline committee hearing, they're doing it the same way, right? Regardless of what we determine the range actually is, right? So I don't really have too much feedback, I guess, on the range itself, because I don't know, like, the history of how they came up with these numbers. I'm more concerned about the practice. It's so yeah. And I think, I mean, there's definitely some of these that we'll look at, and we could have some pretty clear feedback around, like, does the range feel like it matches, right? But in something like this, like, as we're getting into some of these broader ranges, I'm not quite sure if I have any particular feedback on the actual numbers themselves, or like where that's to start at, whether we're starting at 2 days. Like if I just said, well, I don't know, I think this is more serious, I think it should start at 10 days to termination rather than 5 days of termination, right? That's just my opinion, right? And it's not really founded on anything other than kind of how I'm feeling at this moment, right? So, and I don't know if the process in which we determine the discipline and how we do that, the actual practice of it, and standardizing that practice, I don't know if that's a discussion that we could even determine here, if that's more of I think with the city attorney and other ways of how we're kind of establishing that as like a city practice, that we all agree upon.
Maybe some examples could give a little guidance here.
Specific to workplace violence, or just discipline in general?
To workplace violence.
Sure. And I can take both inappropriate, but one using words of violence fits within this narrative. Is like, hey, I think we should take our differences outside, like meet me at the flagpole at 3 p.m. after school, kind of thing, versus me punching someone in the face. I'm sorry for being so graphic, but it's like, okay, so obviously there's violence there, one word, one in action. That's definitely one aggravating up based on, arguably it's criminal also, so that's a different allegation. But yeah, so that's where it might start on the lower end, might start on the higher end, depending on the circumstances.
This is very serious stuff here, because the threat of violence, like you just described, meet me outside, and punching somebody in the face. I think they both are just absolutely horrible, especially when it involves law enforcement, because we in law enforcement, especially in patrol, depend on each other to cover them, to back them up, to show up when they call. You can't have attitudes and beefs and disgruntledness going on. That's why the threat of violence ought to be very severe. It ought not be light. It should never be one day off. It should be, you threaten to fight him. You guys want to fight? 3 days off. We don't fight here.
Mm-hmm.
We cannot fight, because if you say, I need a 1040B at 56 in Genoa Street, and somebody said, I don't like Reggie Lyle, so I'm slowing down. You have to have been in that circumstance to understand that circumstance. And I don't want to tell stories, but I've been there.
Yeah.
And so you out there by yourself. So then that changes how you police. You don't police as and I'm using the word aggressively in terms of not physical aggression, but acting out your suspicions, wanting to go the extra mile. What you do, you find officers. I used to call it playing dodgeball. They're trying to avoid, if it's a suspicious noise over here, they want to go in the other direction, as opposed to going to determine what is that, what's going on here. And so how you break down the safety of the citizens is by having these idiots having these beefs about over women, over gambling, over what else? Well, women and gambling is probably the biggest ones that I remember in my career. And it's just an anathema. So I don't know if we're there yet, but I think if you're going to fight, it starts at 3 days off. It doesn't start at 1 day off. What we want to do is have a deterrent.
It actually starts at 5 days. Take it 2 steps better.
Okay.
5 days.
I agree with that 100%. Yeah. 5 days is a hefty suspension. That's a week's pay almost. That's a lot.
And I shouldn't say I've never come across this, but this is not a common manual of rules section that comes across my desk. So that's why I'm a little bit light on the examples. I'm sure if it did, I don't think there'll be much discussion on what level of discipline, because it's just not a common one. So I'm not too concerned about this one compared to others.
Well, you're fortunate. You've gotten the law enforcement when all of this, when people of color was just getting in law enforcement, that's when it was huge.
Yeah.
When women came into law enforcement, that's when it was huge. All these threats and, what I'm gonna do to you, and or better yet, what I'm not gonna do.
Right.
The time you call for cover, don't you out there all by yourself. Some dangerous talk.
Right. 5
days off. And if you got 5 days off at OPD, that's probably why you haven't seen a lot of it, because it's a deterrent.
Yeah.
So that's one thing is working good.
Things. One, I wanted to welcome Kathy Leonard has joined us. Hey, Kathy. Good to see you. And
thank you. I'm glad to be
comments?
here.
Yeah, I just wanted to see if you had any comments or any thoughts since joining us.
No, because I came in midway on this topic, so I'm just listening. Yeah, I don't have the I didn't get the beginning of this topic, so yeah, thank you.
No problem. Great. And secondly, again, when it comes to like days, I can't tell on the screen, but I'm looking more at Deacon Lyles and DC Hubbard as well too, because this is it's your profession. You guys kind of know like where that lands, and again, when it comes to discipline and messaging around discipline to officers, like I don't want the narrative to be like, oh, that guy on the commission, and the gang intervention dude in the community, he made all the rules for us. Like, no, when it comes to actual days and so I'm deferring to the professionals, to the staff that knows, and again, I'm more interested in that other discussion of like just kind of the practice and how commissioners go in and follow that same routine so that it removes the subjectivity of that process itself.
Well, just remember this: if the esprit de corps is broken down in the police department, you get poor policing. the direct result of cliques and groups that are, at each other and beefing with one another. The people who pay the price is the citizens.
Yeah. Okay. So am I hearing not to touch workplace violence? We're good with that range?
Yeah, I like 5 days.
All right. Great. Next one is 31428, notification criminal. This one, pretty broad range on the first one. It's a 2-day suspension all the way to termination for the first offense, and the second offense is termination. And
Now, this is notification if you were off duty and you got involved in a criminal act. You have to notify OPD and the chief of police that you were involved in some kind of incident.
that's right. That's right. We actually agreed a few months ago to eliminate this section and wrap it into 31448 because it was confusing. I'm still dealing with this problem today, a case I read today, in fact. This one is, I think, better because it basically says reporting violations of laws, ordinance, rules, or orders, and there's a duty to report in here. And I'll just break it down for you because there's a lot here, and I know we already covered this, but in short, uh, in our DGO, Department General Order M3, if I, let's say, see someone come in late to work, okay, I do not need to make that an internal affairs investigation. I can handle that at my level. I can say, you were late today. Is everything okay? And then handle it informally to include maybe a supervisory note file, training, whatever it may be. If, however, someone commits a class 1 violation, let's say workplace violence, okay, I hear, hey, someone used workplace violence against another member. I don't have discretion there. I have to report it to internal affairs. Okay, and our policy is very clear on that. That was a standalone rule. We now want to wrap in if someone is arrested uh, or has law enforcement interaction that needs to be reported within 72 hours. Okay. This is very important. It's not just telling on other people, it's also telling on oneself. The reason why that's important is because that misconduct can go undiscovered for quite some time. If I get arrested tonight, for example, and I don't tell anyone, and let's say the department that arrests me doesn't know I'm in law enforcement, so they don't make any notifications, I can literally get away with it unless someone tells the Oakland Police Department. So the onus is on me to self-report. So if I get arrested, I within 72 hours, and we've made it 72 hours because we have to account for jail time if appropriate, to make a notification to the police department. I can tell you that people do self-report, yes, but I have had a few that have not. And we're talking about 6 months have gone by, and I had no idea in internal affairs that this happened. And now we're trying to recover evidence and everything else from this 6-month-old arrest. And it really cripples us. So that's why this may seem harsh, but it's a big deal where it starts with a 2-day suspension all the way up to termination, but the second offense is termination.
Are you seeing a lot of those? Or is that just
No, it's not an epidemic. I would say more times than not, I am notified. We are notified. And I give credit to even the members who have been arrested who did the right thing to notify us. But there have been a couple that have not. And again, very frustrating. You should probably can tell in my tone because again, it's hard months later to go back and figure out what happened and then hold them accountable for why they got arrested.
yeah. and 2 days off here, I think is appropriate again. And not the more extreme, like 5 days or whatever, because if 5 days, he probably won't ever tell you. You want them to come in and let you know and not run the risk.
Right. And that lower end kind of helps with they told us, but they told us, 82 hours later, not 72. So
Yeah.
that, but certainly the purposefully withholding that information is certainly an aggravating factor, and it would be considered. Yeah.
And they are innocent until proven guilty. So
Right. Yeah. Okay. Any questions on 314.28? Great.
Sorry. So the former rules I was looking at outlines the reasons that would prevent them from being compliant within that timeline. Do those items still stand?
I'm sorry, say that again.
So, the original rules, it does identify events that if they were to occur, that prevents them from being compliant within that timeline that we're setting, the 72 hours. Would those still stand?
It would. We still have the 72 hours here. This is the mandatory notification.
Uh-huh.
We don't necessarily explicitly say we don't say we just give them 72 hours. We don't say
Okay.
72 hours assuming you're in jail. We just give them 72 hours. Uh, we also like have consideration for attorney consultation. So for example, one of them is if they're named in a lawsuit, unless it's the city's also a party. So let's say I'm involved in something off duty, I'm named in a lawsuit, I have 72 hours to report that.
Okay.
Is arrested in accordance to 834. I have 72 hours. My California driver's license is suspended or revoked. 72 hours. Cited in lieu of arrest. 72 hours. Served
Right.
with a civil or administrative. So yeah, those it doesn't it just yeah, 72 hours.
Okay.
We did have a discussion before of whether 72 hours is too broad or too narrow.
Mm-hmm.
We do have a pattern at OPD about thinking in 24, 48, 72. So that's why 72 it's like people know that. If I put out some other random number, I think they'll be more apt to forget it. So that's why 72 is a good one.
Yeah, makes sense.
Yeah.
Okay. Thank you.
Okay. 314.42, obedience to laws, felony system, serious misdemeanor. Um, so this starts with a 2-day suspension all the way to termination for the first offense and termination for the second offense.
242.
The um, this does not mean conviction, and I think that's important to note here when we talk about obedience to laws. It's is there enough is there a preponderance of evidence for internal affairs, this is administrative, to believe that the misconduct occurred? It is not proof beyond a reasonable doubt. Okay, so and I'm just going to use domestic violence because I usually use driving under the influence, but that is a standalone section as you see here. But let's take domestic battery, which is a serious misdemeanor, or could be a felony depending on if there's injury. Let's say the DA does not charge it. So whatever agency does the investigation, they go to the DA doesn't charge it, and let's say they cite that the victim is not cooperative. Okay. That does not mean that internal affairs cannot sustain for this section based on the preponderance of evidence standard.
Excellent.
So the range for that, the first offense is a 2-day suspension of termination, and the second was termination.
because in fact, internal affairs action was held in abeyance to allow for the DA to do its thing first.
That's right. Yeah. So the way that goes is we toll it. So we don't do an investigation until the investigations division does. That can take weeks or months, sometimes years. That's a different story. And then we do our own investigation. So we can compel people to give a statement, unlike investigations. So, the officer, let's say, does not have to give a criminal statement, but when they come to internal affairs, that they do. So we, based on that compelled statement, we have a different set of evidence, if you will. So yeah, that's a lot of people get that confused. They're like, well, I didn't get charged, so how can you sustain me? It's like it doesn't, those two things don't mean anything to each other.
I have a same question. Does this happen a lot nowadays in your experience?
Um, we we get a lot of these allegations. I don't want to we don't have a lot of sustained cases, but we do have a very, based on the latest uh, the reason why we're out of compliance with task 5, I'll put it that way. Uh, Criminal notification and investigations became, and still is, a big topic of discussion. So we have a pretty large amount of criminal investigations going on.
Mm.
But we base those off mere allegations, not necessarily reasonable suspicion, just to launch it. Whether we get a sustained allegation out of it, that's a different story.
It used to be so prolific decades ago, very, very commonplace. And I thought it had, with that law coming in that, an officer could be terminated, get his gun taken from him, and no longer can be a police officer in the state because of domestic violence. I thought it kind of broke the back of that, but it's interesting.
Yeah.
And also, when you say that the DA's process could take months, if not years, is the officer still on leave without pay?
Yes. That's if the chief chooses to put one on administrative leave. And I'll give you kind of a unique example is an officer involved shooting. Technically, it's investigated as a crime. They may not be on administrative leave, but it can take a long time for the district attorney to decide whether to charge or not charge that officer. It's unique. So, but they're still working. There are some who are put on administrative leave based on the seriousness of the offense. And depending on who's doing the investigation, usually not OPD, because we understand doing a thorough investigation expediently, because we know we don't want that person to be on administrative leave. We want to have a disposition to it. But at an outside agency where there's no rush for them to do it, yeah, they can be on paid administrative leave for quite some time.
We got to work around that.
Yeah, that had me going when I was chair, the whole Skelly.
Yeah, I remember.
Yeah.
We've gotten a lot better. We have. Our Skellies have drastically improved.
Right.
The admin leave is still a problem, but I would say we pay more attention to it because we have these biweekly NSA update meetings based on the September court order from last year. And so we're much more in tune to what's going on and understand that someone cannot just sit at home without us knowing for a long time because we know about it. Yeah.
Right. Very good. It's good to hear that.
Not only that, my concern is that it contributes to the deficit that the city faces. Our funds are scarce, and we need every penny that we can get. And so I know there's a lot of officers that are on leave right now, and it maybe 80 something was the last count I heard, 80 or 82. And that is distressing. When you think of all those salaries that are going out of the door, but the residents aren't getting any benefit
Yeah.
from those officers being on leave.
And those officers, I would hope, Captain Hubbard, you're looking for some sort of desk job that they could do.
Yeah, it's a tough call for the chief because there's a risk to bringing them back from administrative leave, and the 80, it's not just administrative leave. A lot of them are medical, but yeah, it's a risk. But there's definitely more of a benefit to bring them back if they can work a desk assignment because at least they're helping the city as opposed to being at home.
Yeah, 'cause when I work for the port, you bring people back and then they trip over something.
Yeah.
So carry on.
Okay. Since we're on the subject, I'll go to the next one here. Obedience to laws driving under the influence, and I can't pinpoint the time, but these two things used to be merged, and I think they made them stand alone because driving under the influence is definitely more applicable to what people would get in trouble for, and so we made it a standalone section. But as you see here, the starting point is a 10-day suspension all the way to termination as opposed to a 2-day suspension to termination. There is a footnote here about it may be held in abeyance if approved wellness program is completed. So it could be where, let's say this, it's the officer's first and hopefully only arrest for driving under the influence, and they agree to go into a wellness rehab program, successfully completing that program with a probationary period could unwind some of the discipline that was imposed. Any questions on 31442 when driving under the influence? Okay. That takes care of those two. All right. 31449. Did I? Oh, you know what? It's that one. I need to change that. So we already talked about that one. Now that we wrap those in the same one, that takes care of that one. This is the reporting of misconduct. So we covered that. Use of privileged information 31470. The first offense is a 10-day suspension and termination. The second offense is termination. And that one is members and employees are prohibited from using information not available to the public gained through their position as a law enforcement officer or within the department to gain a financial or other benefit for themselves or another. We didn't have any changes with this one.
The person was either very angry.
What did you say the penalties were?
10 days. First,
Yeah, it's a 10-day suspension and termination for the first offense, termination for the second.
Okay. All right.
I don't have an example for this, and that's
I guess I'm a little concerned about the 10-day suspension.
So our next,
Use of privileged information. I mean, that's pretty bad. In any other job, I think you'd be terminated for doing something like that.
you mean
That's
on the
just so
first-
egregious.
the couple's roommate told me.
On the
It's
first
so
offense.
egregious, like, I know, but you shouldn't be doing it in the first place. Any other job, you probably would not get a suspension, you'd be terminated.
Yeah.
And I guess more so, does every officer on the street have access to privileged information? I guess so, because they can look up someone's record or look up someone's name.
They
Is that
can't.
true?
Yeah, yes, it is true. It is true. That I'm trying to think of it. Sorry for my pause here. I'm trying to think of a situation where doing that would benefit you personally, financially, or for.
According to the roommate, Savion answered the door
Oh,
and went outside.
Somebody needs to mute.
Yeah.
Savion's roommate said that he went to the window.
Well, I can think of this a situation. It was with another agency, but one of the employees gave some financial information to a family member to use in a child support case. And that person was terminated.
yeah, that is a good example. I could think the same for landlord tenants. Like, let's say that I own my own, apartment, and I use privileged information to determine who should be my tenant or not. That would fit into this category also. There'd be other allegations with that. I think that's a misdemeanor.
Who are the three suspects?
Can you
Yeah.
pass?
Detectives immediately get to work.
Yeah, I'm just stating my objection to that, what seems like a slap on the hand to me.
Can you ask whoever that is to mute?
I think it's Miss Kathy's when she in the background, maybe when she's off mute. Because I don't see anyone else's square lighting up.
I'm sorry, that was me. I've silenced the other noise. Thank you.
Thank you.
Okay, so Kathy brings up a good point. If so, the first offense is a S10, suspension 10 and termination. So how do we feel about that range?
Well, I'm kind of agreeing with Kathy because this privileged information is also a criminal offense in California law.
Yeah.
Government Code 8314 prohibits anyone from using privileged information in, like DMV files, in going in the DMV files and running a NCIC check on a name or something like that, or a driver's license, and then finding someone's address and all of that and sharing that with, using it yourself or sharing it with someone that's not a criminal, in your course of duty. So it makes it a criminal offense.
Yeah, I think that's immediate termination.
Okay.
Is this unlike the discussion we had a few months back where we were debating whether an officer who was called to a scene and got certain, personal information, address, phone number, whatever, and then turns around and uses it personally to hit on the person?
There is a different section for that is converting a contact into a personal relationship. That is definitely part of this. I think what we're talking about though is obtaining information to then turn that personal or professional into a personal relationship. So let's say I meet a girl on duty, me asking her out or taking advantage of her situation to have a date with her is one thing. But if I'm then running a file check on her and I'm looking at her background and I'm trying to determine her phone number or asking someone, that's where I think it crosses the line into this section, use of privileged information.
And that's where I departed with you. Yeah. Because I think any conversion of that personal information that you receive through an official contact is a violation.
Yeah. Yeah, to Deacon Lyle's point too, it's if I use CLET's information, DOJ, that's a misdemeanor. And so people can take it one step further by looking at real confidential things, which yes, we do have access to, and that would then be a criminal allegation going back to misdemeanor allegations, that the previous section, that would be also applicable.
And I think you ought to cite Penal Code 424 in your whatever you write up about that, so the officers can know that this is a, it's a misdemeanor. It's a wobbler. In fact, it could be a felony.
Wait, are you saying that the use of privileged information is not a felony?
No, it could be a felony.
But
It
they are
seems like under any circumstance, it would be a felony.
No, it's not always a felony.
No.
Sometimes it's charged as a misdemeanor.
Yeah.
But
Under what circumstances would it be charged as a misdemeanor?
I wish I could tell you, but I know that I'm trying to let me think about that. If I can come up with a circumstance.
I'll give you an example. A friend of mine says, "Hey, I think I have a warrant. Can you run me out?"
Yeah,
That would be a misdemeanor.
they're not going to charge.
It's wrong either way. I'm just saying it's like that simple act would be a misdemeanor consideration.
I'm sorry, what did you say? Give the example again?
Yeah, a friend calls me and says, "Hey, I know you work in law enforcement. I think I have a warrant for my arrest. Can you do a file check to confirm that?" That would be a misdemeanor.
But again, I call you to my house, somebody stole my bike, you take the report, then you call me and ask me out.
Yeah.
That's okay.
Well, we have a different section for that, but that's not using privileged information.
What is privileged information?
But it is privileged information. If
Yeah.
you're taking information from the public and you're getting personal information, that seems like it would be privileged information. Because it's not something that you would share with anybody other than other
you wouldn't have had
officers
it. You
that
wouldn't
are
have
involved
had it
in that
unless
case.
yeah, you would not have had it unless I called you on an official matter.
Okay, yeah. I mean, I understand. I think we can still get there through an investigation. I guess I'm thinking of like she gave it to me because I'm the officer there versus another officer went and I got that information through our system. You know, I'm probably splitting hairs here, but
I think you are.
Well, I argued the other side of the coin, and I think that's what they're driving at. I know that's what Marcia is driving at.
Yeah.
I'm like, oh, no, not this again.
I haven't moved off that point. If you go and you doing your job and then you get the information and you happen to remember the person's address, or you don't go by the house, but you remembered the phone number, or you and you meet them by coincidence at a shop or whatever, and you speak again. You guys don't know how many marriages with police officers that happen just like that.
You know, that is not the example. And you know
that's not the example that you like to use. But what I'm arguing is that these human beings who get together, those who wear uniforms and the public, they do end up
I'm not
dating and marriage and stuff, all of that.
If we bump into each other the next week at a restaurant,
and I remember your phone number,
or at the lake, no, you shouldn't be remembering my phone number.
See, that's the part I'm driving at. You can't tell an officer who's trained to remember these things, to make these connections, don't remember that. No, she is attractive to me.
No, my example is different, and it really wouldn't require any splitting of hairs. I call you to my house, my bike is stolen. I give you all sorts of whatever information, my cell number, which you would not have had. And then you turn around and call me and you say, "Can we get together?"
I yielded to that.
I would have a major problem.
Marsha, I yielded to that about 6 months ago.
No,
that's not what I'm talking about.
Okay, well, if you yielded to that, then we're good.
Yeah. The reason why you brought it up because you want to hear me yield to it again.
Well, that is so not true, Reggie.
Okay, all right. I'm talking about the relationship between police officers and the public, they do end up in, dating relationships. It does happen.
Okay, yeah, I mean, that would be in the casual course of things in life. We meet again, yes. But if you use that information that I gave you about my stealing my bike, and you call me 2 days later and say, you know what, whatever.
All right, I submit. I yield.
I missed
I
this
just want to say,
argument.
if you bump into the person a week later and you happen to talk, I think that's a totally different
Different thing.
situation, and it's an
Right.
innocent situation.
That's
Right.
what I
Because
was
you didn't
trying to.
call that person, you just happened to bump into them.
I don't have
Unless
a
you were,
problem with
unless you
that.
were stalking them or something, but no. But yeah, so I wouldn't put that, I wouldn't classify that
Okay.
No, I would not
as
either. I would not either.
yeah,
But that's not the hill we were fighting.
yeah. But I still am troubled. I'm still am troubled by the 10-day suspension. I think it should be a stiffer penalty.
Yeah, I mean, that's why we're here. So what do we think?
Yeah, I don't know what it would be, but it needs to be something that would make a officer think twice and say, you know what, I may be terminated. I may be on suspension for 2 months or 3 months or whatever.
Like that other
Do I
case.
really want to misuse this privileged information that I have? And I think 10 days isn't going to cut it for someone.
There's a philosophy that if you have to suspend somebody more than 10 days, it shouldn't be working for you.
Well, I said automatically, I said at first, I think it's a fireable offense, but
that is a management philosophy. They go 1 to 3, 1 to 5, 10 days. Anything after that, fine. But you have departments that suspend people for 30 days and bring them back. And those officers really never rehabilitate themselves. They really dig themselves in a hole and they end up doing something different and all that. So if I got to suspend somebody for more than 10 days, they ought not be here. The threat of 10 days ought to shake them up. That's half a pay. And what do these guys get? $15,000 a month? So they got a whole paycheck, half a paycheck taken from them.
So are these calendar days or are they working days?
Working days.
Yeah.
Working days. It's all about money.
That's 2 weeks.
Yeah.
so if you're suspended, I assume you're being suspended without pay.
Without pay.
Oh, absolutely.
And you lose seniority too.
Mm.
Oh, now that's critical. I didn't know about losing seniority.
Yes, it is so severe.
Yeah.
It is so severe. And it is a major deterrent for most people.
Mm-hmm.
I think the loss of seniority would make someone think twice about
sometimes it's more impactful than
doing
the suspension days and loss of money. Yeah.
And I wish I know that you probably can't get this, but I wish it all ended up with cash and not allow them to use vacation time and all of that and comp time and all of that. Just look, you just lost 2 weeks pay. So don't do it. But if I got, I don't know, how many weeks on the books can you keep in Oakland?
It's unlimited.
Oh my God.
Really?
For a vacation,
Wait, so you're saying that while they're suspended, they could use some of their vacation time? That defeats the whole purpose of discipline.
Exactly.
It's not automatic. It's something that one has to appeal to the chief, and it's not automatic.
Well, what would the circumstances be that you would let someone who's been suspended use their vacation leave to cover it?
He's a great homicide investigator. He's got
not good enough.
He got some
not good enough. So they're not really being penalized then. That's
no,
not.
They are.
Yeah.
And I agree with that. That's why I've always been against I want your money. I don't want your comp time or your sick time and all of that. No, I want your, you don't get 52 weeks. You get 50.
So is that what the policy is right now?
No, there's no policy on the matter. It's it does occur, but it's actually rare for the chief to allow someone to use their personal time to offset the suspension days.
Even if they're the best homicide investigator on the force?
Yeah, I'm
I'm
not
thinking
saying it
about
doesn't
even
happen.
application of
Yeah.
Yeah, the poor slob who's not the best investigator has to eat all that time. But
Yeah,
the one that that the chief thinks is getting what is he getting, a poor rap? Or I mean, why would you let the mitigation of the penalty, which is the pain of losing 2 weeks of pay, be mitigated by using your leave time?
I've never seen it used for something as severe, let's say as 2 weeks, but I have seen it used for like a 1 day suspension for a vehicle collision that's preventable, something like that. So it's not. I mean, it's
But that
serious.
mitigates the effect, if you will, of the punishment.
Yeah.
That makes no sense to me.
Well, again, you got to look at it, and I'm not arguing for it. I'm agreeing with you all, but you got to look at it from their perspective. They're saying we need this person. This guy is talented. This guy or woman is vital to our daily operation, and so
Even though they're engaged in misconduct.
yes, I've seen it happen. I'm not defending it. I'm just saying in the real world, these things do happen in law enforcement. And it does, and my experience is not just with Oakland. I'm talking about law enforcement in general.
Well,
they do bend over backwards to mitigate. Well, we heard, you read what the judge wrote, right?
What? The judge wrote in what?
In the NSA agreement, the judge said that he felt that OPD was doing everything they can to not hold people accountable.
Yeah, and that being the case, and I honestly have worked in labor and employment for 47 years, and I've never seen a person be able to cover a penalty of being disciplined, time off with leave.
Then you see, and this is a different culture. This
You
is
got that right.
This is different, and so
Yes,
you guys gotta have to not I'm not saying agree with them, but you gotta put on their glasses and see how they see things. If you want to correct,
I'm saying, how does that change behavior if, okay, yeah, I did this, but I've got unlimited leave, like Captain Hubbard says, it just keeps rolling over. I can keep a bank of many, many hours. And well, they think they got me and that they're going to hurt me with this punishment, but I got leave. I got enough leave to cover it. So screw them. So I'm not feeling this. I've never heard of this before.
well, I've heard it for 30 years. And
Well, I think that we should rectify.
And it's not.
I think we should rectify that today.
Yeah.
Well, okay, let's rectify it. Just know that this is a meet and confer issue, and just know that the union's going to get involved in the politics of all of that. I mean, the fact that
that doesn't mean we shouldn't do what we feel is what we should do. And if they're successful in clawing that back in negotiations, by giving us something else in exchange, that's the nature of negotiations. But I think we put
while we willing to rectify it, and like Kathy said a little while back, that the city needs money. That's where the city needs to deal with it, because when those people retire, they sell that sick time and vacation time and make a demand of the city for that money. Now, most private industry won't let you have no more than 5 or 6 weeks of vacation, and that's it. And they won't let you have an unlimited amount.
Well, at the Port of Oakland, they gave you everything that you had on the books for vacation, but not for sick leave. I think there was a 3 for 1 hour for every 3 hours or something like
There are a
that.
lot of different formulas.
Yeah.
If you want to get your around the managing this budget, that's one of the issues you have to take. There's no reason why a person should be allowed to have more than 6-week vacation time. Why should they have a year's worth of vacation time?
Right.
What
I
is that?
agree.
What,
If you
that
don't
are
take
you
your
doing-
vacation in a year, you lose it.
Yeah, you
I know
lose it.
my uncle worked in I can't remember. He was a union rep as I remember. And he never was called in sick. He never went on vacation. And when he passed, my aunt, my mother's sister, got all of that. I mean, it was so much money. It was
It's a
unbelievable.
savings account.
So
It was unbelievable
and
that the payout and also his retirement. It was a
It's not-
windfall.
it's not a
And it
best
should be
practice.
if you don't use it in a year's time or 2 years' time, you should forfeit it.
It's not a best practice in 2025. And you can go through private industry, you can go to government industry, and you'll find that the people who allow that to happen are poorly managed cities.
Yeah.
Well,
Yeah.
and
Yes,
I'll
I
also say
agree.
aside from the financial burden, I think where it really impacts what we're looking at is the mental health of officers, right? And I know, it's not healthy to not take vacation, right? We've talked about just, training opportunities, coaching opportunities, and this is like a command staff supervisory issue, I believe, across the department where staff need to be encouraged to take some time, take some breaks. I don't know if just because the operational force is so low, you just can't, right? I mean, I know that that's a reality too, that folks just can't take time off. But that is something that we need to continue to look at. And I don't think we're ready to, I agree that this needs more work. Don't think we could rectify it right now. We're 5 minutes over time, and I wanted, so I'm thinking that we could just pick up our next meeting on this discussion. Maybe we'll have some time to further review it, chew on it a little bit more, and then have a further discussion next week about this. And then certainly I think, I think we need to also make a note just on this unlimited overtime issue, just on and just where that also kind of presents itself in other spaces as well. I mean, that's wild, man.
Right.
Yeah.
And thank you for mentioning the mental health. That is a very stressful job. I had an uncle who was killed in the line of duty, and his job was stressful. So officers should be encouraged. Take your vacation time because it's going to serve you well, and it will also serve the residents of the city of Oakland well.
Once you get 6 weeks vacation on the books, you can take your vacation every year and still build up vacation.
Right. Because
So-
you're building it
So
up while you
you guys got to know that it's a savings account. That's how they look at it.
Yeah.
Well,
And if they say, look, I'm not going to take vacation time, I'm taking comp time. I'm taking sick time, but I'm saving my vacation time. That's a bank account.
But
So
you should only take sick time when you're actually sick. It shouldn't be used for some other reason.
Well, if you're going to fiscally manage the city better, these are the things you got to look at. And you got to remember that all of the union is going to be against you, and they're going to use all of their influence with the elected officials not to look at this. Do not think that the city of Oakland hasn't looked at this before.
I know, and the time is now for the city to stop yielding to OPD.
well, and again,
The city is always coming out, and the residents are always getting the short end of the stick, and it's time to.
OPD.
And I know that the union is very powerful, but our leaders need to not be persuaded and to think about the overall picture of the health of the city, the health of the officers, and our budget. We've got to look at all of these things.
Yep.
And so, I'm tired of seeing, well, I don't want to get into a whole thing. But yeah, I think that there needs to be a little more give and take in these situations and not always the city giving up too much.
Yeah, well said. We'll leave it at that. It's a good way to close the meeting there. Is there any last final burning thoughts or announcements, Chief of Staff?
There
Um,
was no one in the audience, so you guys were good. It was just participants.
all right.
And so our next meeting is on the third Wednesday of this month. And that is the 15th.
Yes, the 15th.
The 15th, yeah.
Mhm.
So we'll try to rectify this issue, but after this commercial break. And then in the meantime, DC Hubbard, it'd be great to see a plan, or maybe an example of how one could start dissolving their vacation hours and giving it back to charity or something like that. I mean, I'm sorry, giving you a hard time, man, but I think
There
that's
is
what,
a process for donating it to another employee that needs it because they don't have any for.
no, I'm saying that in jest. I do want to highlight that's what makes this group here special, is we're talking about some real sensitive stuff and things that are very that really look at root cause issues of kind of like how we get into trouble with bad policing and cities being frustrated, and just kind of trying to untangle this knot through these real honest and frank conversations. So I appreciate you all, and we will leave it at that and see you all in 2 weeks at 6 o'clock, and we'll see you, Chair Emerita, at 6:15-ish around. Take your time. We're always happy to have you join us when you can, and have a good night, everyone, and thank you again, DC Hubbard, for all your work around this.
Thank you.
Thank you.
Thank you, everyone.
Bye.
Good night. Have a good
Bye.
rest of the week.